confidentiality, that's what we're going to do. We are going to talk about the laws and all the policies and procedures. So, of course, you know that it's all about FERPA and IDEA and House Bill 330. And just know that really what it all comes down to in the beginning is that we need to make sure that we're always complying with our privacy acts. It's important. Because if we're not, and we're ever caught in a situation that we're not, and a parent is saying, hey, you're talking about my kid out in the open at the soccer field, ball field, then these are things that could happen. They can withhold federal funds, and then parents are obviously ready to redress. So they have federal guidelines and state guidelines that were written for it, for confidentiality records, and records are going to be the things that we're going to talk about right now. And you have a annual given public, the paper that is sent home to parents where they have to return it to say, I don't want my information released. That's that paper that all the kids take home, and the only way that the parent can say, I don't want the information about my student released, they have to return it, okay? So that's that notice that's sent home every year with all their paperwork they have to do. This is the information of the directory. This is what's released a lot of times to military, okay? So if a parent returns and says, I don't want it released, it can't be. But those that don't return the form, so we can release that information, and this is the information that's released to them. Name, address, telephone, and things like that. Talking about protecting all personal data, identifiable information that talks about their address and everything that we just talked about. And any records that are collected over years, times, from kindergarten until they release from high school and graduate. The requirements also apply to discussing students, okay, and their records. So I know many of us, a lot of times we're out and about and you're like, hey, you're about to get one of my students, okay? Make sure if you're in Walmart, Kroger, you cannot have those conversations. Somebody overhears you, then that is you're breaking confidentiality, okay? Make sure that any type of information that is even said orally or in writing, that is communication, and that is student education records. So even all of the notes that are sent home and everything like that can be used as their records and put into their files. And it tells you again right there. And this is the different types of educational records. We all know when they transfer from school to school, a lot of this information will follow them, okay? I just got done telling you that anything that is written, so anything that's in their agenda or notes that are sent home and any types of pictures, that's why you have to be careful with Facebook and things like that too. Make sure you always have permission. All right, because you never want a situation where a parent says, I didn't give you permission to post my kid's picture. Personal notes, law enforcement records, and medical records are not educational records. So, you know, those are things that we don't move on to other districts or that we can give the student when they graduate. Some people will come back and say, I want all my records back. We don't have to give those things because those are actually, that's with FERPA, so we don't give those. Any child that has reached the age of 18 can have their records if they request it, and when they're going to college or any other VOTEC school or anything like that. If a court has established limited or full guardianship, a student at the age of 18 is not eligible. These are for our students that are low incident, and guardianship is given to their parents. So when they turn 18, they cannot make decisions for themselves. Their parents still make their decisions. So if they came to you and said, I want my records, you wouldn't be able to give it to them. LEA just gives you the definition. It's the local school district. And it repeats itself. I don't know. So this is different information that it can include. And this is a list of personal characteristics or other information that makes it possible to identify a student. So here they're talking about, sometimes people will say, without saying that, I never said the name, but you list all the things about that student, and the person behind you goes, I know who they're talking about. So even though you don't say their name, you're still breaking confidentiality because you're talking about that student. Amendment of records pertains to changing or deleting or destroying information. Okay, we cannot do any of that. Before, especially special ed records or anything like that, before we can destroy anything, we actually have to put it in the paper. That's the public notice. We have to be able to say, hey, we're going to destroy the records. If you want them, you have to come back and get them. Otherwise, they're destroyed. Child find, that's something we put in the paper to seek and find any children that need some services. Use the newspaper, social media, anything like that in order to notify parents. Also has to be published in all languages so that anybody that is not able to read English or anything like that has a second language. As English is their second language, we have to be able to post it in their native language. So access rights, meaning that if I have somebody that comes up to me, a parent that says, hey, I need their records, they have access to the records. These are the people that have access to it. There's an asterisk next to foster parents because foster parents can have access, but they cannot make decisions. If parent rights are not terminated, they can't make the decisions. However, they can review the records because they have the child and they're a stakeholder. So these are all the different people that can look at the records. And you have to make sure when they do, you have to have them sign off on it so that you have record on who looked at it. Anytime a parent or even the child is requesting their IEP, we have to give it to them. I can't say in about a week or two. We have to give it to them right away. If there's due process or anything, we have 45 days. Education records also includes on more than one child, the parent shall have the right to inspect and review only the information related to their child. So what that's talking about is when you have an incident, if you have a fight or anything like that, I cannot, when I give the statement about what happened, I have to make sure I have student A or student B. I can't have the other student's name in there to protect the rights of the other student. Private notes. Right here, when I talked about earlier, by staff members, become part of the educational records and must be available for inspection review if they are orally communicated to others. So if you write your own note, you're fine, and you don't share them with anybody. But if the minute you share them, they become record. All right. Of course, these are just the things you have to make sure you have the name of the party, the data, and the purpose of why you're looking at the records. And you have to make sure you have an interest in the child, meaning that you're a stakeholder, a parent, teacher, staff. Must maintain a current list of names and positions who may have access. So not everybody, that's why on Infinite Campus you don't have access to every student, just the students that you need. They also shall provide parents on request a list of types of location of education records regarding their child with disabilities. So anytime you have a child or a parent that's looking for records, just tell them to call me and we'll find them. Amendment of records, that's who believes information in the education records are collected. That just comes right back to me, or if they're used, inaccurate, misleading, that means you violated. Decide whether to amend the information or if we need to notify. And we have 10 days to do that. We need to advise the parents of their right to records, and that's where we put it in the paper and things like that. In beginning, before ARC meetings, we talk to the parents too and let them know they have the rights. If you are requesting a hearing, it has to be held if the parent is. If the hearing results in the records being amended, we have to give a copy. If the hearing decision is not to amend the records, the same thing, you just have it recorded, and then you have the right for a statement to be included that there's a disagreement. We're going to go to consent. I'm trying to make this as quick as... you have to give consent, the parent does, for other agencies in order to disclose their records. So if you have an outside agency that wants to come either screen or look at or help, you have to get permission first. The directory of information is not needed as prior consent. School officials with legitimate educational interests, so that's when it goes to school, or if it's teacher to teacher, it doesn't matter because you have an interest in the student. Any type of audit or evaluation, and any type of organizations conducting a certain study for the school. Prior consent for financial aid, all of our students that are going to college and things, that you can have, you don't need that, they don't need permission. And then health and safety emergencies, and then state and local authorities within a juvenile justice system. Prior consent is also not needed when you have an individual, it keeps saying it, as long as you have an interest with that child, you are okay. If you are a stakeholder and you're going to work with that child, you are fine. It's when we have people from the outside coming in wanting to look at things. If a parent refuses to provide consent for release of personal, identifiable information, a party may request due process. Here's our safeguards. And we shall protect confidentiality. That's what we've been talking about while dealing with collection of it, storing it, disclosure, and even destruction. I shall assign a staff member to assume responsibility for ensuring the confidentiality of personally identifiable student information. Employee collecting or using any of this information shall receive training. So that's what we're doing. And hopefully we'll get done here soon. And any of the shall maintain public inspection and a current listing of names and positions. So we already have that on file. We're good. Records retention. School districts must ensure staff members are familiar with the follow the Kentucky record-keeping requirements specified in the Kentucky Department of Archives. If you come to our office, you will see upstairs, we have a record room that is completely full. You cannot walk through it because we have to hold on to everything. So once we're ready to destroy, we'll have to post that in the paper and everything. So that's the destruction of records right there. We have to inform the parents to let them know, because if they don't need them, then they're gone. But a lot of parents will come back and get them because they want them. The parents may request that information be destroyed. So even after the year, if they want to destroy them as soon as they leave school, they can do that. We don't have to hold on to them. Permanent record of a child, the name, address, and phone number, grades, attendance, everything, and completed may be maintained without time limitations. So that's why we still have a room full, because we haven't destroyed anything. So if we choose not to, if the district does not destroy the records, there is an outstanding request to inspect. They are needed for compliance. So we will. The child has rights at least 1 year prior to the child reaching the age of majority, which is 18, and the child must be informed of all of the things. Their rights, the rights to be able to transfer of the age of majority. So those that don't, they have to go to court, and the parents get guardianship. Transfer of rights is automatic unless the school district is provided with evidence that there is a court order or legal document indicating the parent is the guardian and the representative of educational matters. Professional sharing, we've talked about this. You just have to make sure you are only sharing with those that need to know who, what, where, and why. You don't have to share everything, just what is needed. So I'm going to kind of go through this quickly. There's scenarios. So, Melissa is going to pass these out that you all have had confidentiality. So the summary of all of it is, just do not, go ahead. Okay. Sign them. Okay, so you have additional access rights to Infinite Campus, and you look up your neighbor's child to compare their progress with your own child's progress. Can you do this? No. All right. Why? Just because you're curious doesn't mean you can do it. So, during a disciplinary conference regarding a physical altercation, A parent requests that you disclose the consequences given to the other student involved in the incident. You tell the parents that you are unable to disclose that information due to confidentiality laws. Was this correct? Yes, that's what we talked about earlier. Okay, and I know parents always want to know what happens to the other kid. We just can't share that. Okay. Juanita and Jim are the natural parents of Marion and a student on your due process caseload. Juanita and Jim have separated, are in the process of getting a divorce. Juanita sends a note to school stating Jim is not allowed to access to Marianne's records. Can the school honor Juanita's request? No. Okay, unless you have documentation that says that parent is in no contact. And you know many times you have that. A parent will say, no, they can't have the right to look at anything. And you say, until you show me documentation, I have to. While shopping at the grocery store, you run into a coworker and begin discussing a student you both work with who is having difficulties with reading. Can you do this? Is it appropriate? No. Even if you're on the phone. I don't know how many times I've gone through and people are on the phone. I'm like, ooh, just because you're not directly in front of somebody.